Hello everyone, I am April MARAMARA, and with me in this research paper is Dr. Abdallah TUBAISHAT, and we are from Zayed University in the United Arab Emirates. Our paper is an analysis of digital evidence admissibility in Islamic Sharia courts. Now, as the landscape of a human activity has now become significantly of digital nature, so have everything that we do, our actions, transactions, interactions, they leave footprints in the digital space. Now, in legal proceedings or any legal case, this shift is reflected with a multiplication of digital data involved. And in a lot of cases, this digital data, digital evidence, could be indispensable. In the same way that traditional evidence needs to be maintained in its original form, say a room, we cannot add like more thumbprints in a room or walk around in a room or in a crime scene. Digital evidence must be collected, stored, and processed without any alteration. And this verification of its integrity is what determines its admissibility in court. Now, the same secular legal system is expected to be applied differently in different countries, depending on the context of the country, whether that's due to their tradition, their culture, and other social contexts. However, in religious legal systems, there is some expectation that the application of their laws are done in the same way or in a very similar manner because of their sources of law, which I will get into in a bit. Now, in practice, of course, there's no unified enactment of these laws because of general diversity of human view and interpretation. And also in Islamic Sharia, it has different sects, the Sunni and the Shia, which adds to this dissimilarity of view. And we wanted to see where these differences lie, particularly in digital evidence admissibility. Now, the sources of law of Sharia are as follows, and this is according to importance. First is the Quran, which is the primary point of reference as it is the direct word of God. It contains laws, regulation, and basis to different issues of human life and its aspects. If a resolution is not found in the Quran, the Sunnah or the religious practices established by the Prophet Muhammad is consulted. And then comes ijma, or the consensus of Muslim scholars regarding a ruling. So this is based on the principle that if all believers agree on a matter, then it cannot be wrong. The last source of jurisprudence, Sunni Shias follow analogy while Shiism follows rationality. Analogy, for instance, is because in the Quran it doesn't explicitly prohibit drugs. However, because drinking of wine is prohibited in the Quran and it has an intoxicating effect on the body, in the same way, because of the harmful effects of drugs, then drugs is also prohibited. Rationality, on the other hand, is, for instance, eating pork is prohibited. However, in extreme circumstances where there is no other source of food, then eating pork can be okay. With these in mind, we wanted to see how digital evidence is treated and admitted in court. We did so by looking at two civil cases in Malaysia and Saudi Arabia. This line of inquiry has been explored in the past, but only in national context. And so we wanted to see if there is a difference across geographic locations. So we took two civil cases from journals, as they provide insight to the case, and these insights proved helpful to help us validate our analysis. So we looked at whether the digital evidence was admitted as well as the context regarding the decision. Malaysia is a Muslim majority country and it has a mixed legal system. They also practice English common law and customary law on top of Islamic law, and it has jurisdiction of all Muslims. The Sharia court, has jurisdiction of all Muslims in the country in respect only to civil law. On the other hand, in Saudi Arabia, it is virtually an all-Muslim country and it practices only Islamic law. In both Malaysian cases, which were both divorce cases, no digital forensic process was involved, implying that the judge admitted the evidence as they were presented. In case number 1, the evidence were text messages, and these are typically authenticated by a forensic investigator by first ensuring the integrity of the device, the data is checked, and its metadata is checked. On case number 2, on the other hand, it involved a digital photo. Photos in this time and age are easily modifiable, even by a non-expert. This can be done visibly by altering visual elements of the photo or changing it in a bit level to hide data in it, and this photo and its medium should be authenticated. However, in both cases, they were admitted without this authentication process. In both Malaysian cases, which were both divorce cases, no digital forensic process was involved, implying that the judge admitted the evidence as they were presented. In case number 1, the evidence were text messages, and these are typically authenticated by a forensic investigator by first ensuring the integrity of the device, the data is checked, and its metadata is checked. On case number 2, on the other hand, it involved a digital photo. Photos in this time and age are easily modifiable, even by a non-expert. This can be done visibly by altering visual elements of the photo or changing it in a bit level to hide data in it, and this photo and its medium should be authenticated. However, in both cases, they were admitted without this authentication process. In Saudi Arabia, now in the case of Saudi Arabia, case number 1, there was no forensic expert consulted. The evidence under consideration were text messages, and this case is of particular interest because of the lack of request from the judge and the defense lawyer in identifying the owner of the originating number. By the way, all of these cases are available in the paper should you want to read it. And as with the first Malaysian case, the integrity of both the phone and the text messages should have been authenticated before acceptance. Despite this case falling under hudud, the judge used his discretion to give a tazir punishment. In case number 2, a forensic investigator was involved. The digital evidence were emails whose origin they were able to pinpoint. However, this is not best practice as bias can be present as the investigator was employed by Microsoft and not the court. The evidence was not taken as strong evidence. In both countries, no digital forensic investigator was employed by the Sharia court. Instead, it was upon the prerogative of the judge to accept the presented digital evidence. This is not usually accepted, if at all accepted in secular legal systems, wherein empirical means usually have greater weight than, for instance, an oath, which is acceptable in Sharia court. As technologies advance, so does our ability to adulterate them increase. This does not only hold true for experts because of the tools I've made available to the layman today, which allow them to add, modify, and delete data. With this said, digital evidence must be procured, handled, and analyzed by experts in the digital forensic field for it to be deemed authentic before being admitted to court. Thank you so much for your time.